how we primarily knew it. But once the COVID pandemic hit, it thrust public health into the limelight in a way that was unprecedented, with the duration, the scale, the scope, and the severity of the pandemic. Local and state health officials were suddenly in the news, and practices and authorities were being questioned, and which is really why we wanted to present this session today, so that there is a basic understanding of the science, the authorities, the law, and so that we can clear up any confusion that, as you know, the pandemic continues to wear on, and as it's worn on, people have also become aware that policies are different from one community to the next in Michigan, and there's confusion about that, or when it's the state health department's role versus local health department's role. So these are all topics that we are going to cover today. And in our second part of this series, this is a two-part session. The next one will be held on February 28th at the same time. And that will be the application of the law. We will have local health department officials joining us that day to talk about the second piece. But today's focus is on the legal authority. And I'm pleased to present our first speaker, Professor Peter Jacobson. Professor Jacobson, JD, MPH, is Professor Emeritus of Health Law and Policy and the Director of the Center for Law, Ethics, and Health at the University of Michigan School of Public Health, where he taught courses on health law, and public health policy. Currently, he is the principal investigator for the Mid-States region of the Network of Public Health Law. I'm happy to introduce Peter, Professor Jacobson, and we will take questions about a third of the way through after Dr. Jacobson's presentation, before we switch to our second speaker, and then we'll take them again after that, and then at the very end. So if you will have multiple opportunities to put questions in the Q&A. Turn it to you, Peter.
Great. Well, thank you very much. Kathy and Arnold, it's a pleasure to be here today. And Colleen and I are looking forward to your questions and a discussion of Michigan's public health law structure. As Kathleen noted, public health is really a creature of law. It doesn't exist outside the law. And as we'll see in its structure, organization, and how public health services are organized and delivered. As you can see, consistent with Kathleen said, COVID-19 is hardly the only aspect. Infectious diseases are not the only aspect of public health that affects our daily lives. Public health is responsible in part for air quality, water quality, sanitation, preventing injuries, safety of food, workplace safety, and as we know, vaccinations. Some of this is controversial, much of it is not. If you talk to health officials, part of what they'll say is public health is invisible when we're doing our job. When things are problematic, as they were with the pandemic, public health is much more visible. So what we want to do today is give you an overview of law and public health. And we're going to start with the sources of public health authority. And I'm going to handle the first part of this, as Kathy mentioned, then turn it over to Colleen to discuss the Michigan Public Health Code in greater detail. Then the third section is what we're calling public health law and practice, where we'll cover some specific issues and particularly focus on COVID-19, and then close with what are some of the limitations on public health authority. So please submit questions. We really look forward to hearing from you. As I alluded to, law is the foundation for public health activity. But there's often a tension between protecting the community's health and unduly intruding into individual personal liberties, often stated under the 14th Amendment in the US Constitution, as we'll see. For example, there remains considerable dissension about the initial stay-at-home orders in COVID-19, the initial lockdown orders, generally closing businesses, even onto the present in terms of mask wearing masks in schools. You need a passport to enter. Do these intrude on individual civil liberties? If so, how do we think about the balance? But let's define public health law as the cumulative body of constitutional doctrine, statutes, administrative regulations, and executive orders. All of these play into creating, and I should add probably judicial decisions, all play into what we think of as public health law. And an important aspect of it is what we're going to focus on today, the Michigan Public Health Code, and the process of issuing regulations and executive orders. It's important to think about the kinds of relationships that public health affects. There's the relationship between the individual and the government. To what extent can the government use public health interventions to guide individual behavior? For example, should a state require bicycle riders to wear helmets or motorcycle riders to wear helmets? Then there's the relationship between the individual and community. And the best example of that really is around the COVID-19 or other infectious disease orders. To what extent is it okay for the government to quarantine or isolate an individual? Quarantine means you segment those who are exposed to an infectious disease until they're no longer at risk of spreading that disease. Isolation is you remove that person who usually refers to someone who is actually symptomatic and affected. Ebola was a good example of this, where many health departments, not many, some health departments were faced with an Ebola outbreak and quarantine. Maybe SARS is a better example, when the city of Toronto quarantined a lot of people who had been exposed. So they were at home, and then they isolated those who had been infected to try to stop the spread of SARS. And the same with Ebola, which they did successfully. Then there's the relationship between the various levels of government, which is an important part of the structure of the Michigan Code. How do we think about the relationship between the state and local governments and between the state and federal governments? We'll get to that in a minute. And finally, there's the separation of powers, the relationship between the judicial, executive, and legislative branches of government. Who should make decisions in an infectious disease outbreak? If it's widespread, should the state be making the decisions? Or what role should the federal government play in the process? Okay, so let's start with some general concepts. And the first is federalism. And this also gets to a question that was raised in the chat. The states and federal government are co-equal units. Each is a sovereign entity. And this dates back to the founding of the Constitution in 1787 and has always been subject to considerable debate and contention. And we see it really very closely in terms of now, in terms of the COVID-19 federal mandates, both OSHA on worker safety and CMS for healthcare workers. Is that a legitimate federal policy process? Some powers are explicitly federal. Defense and nuclear power means that the states have no role in regulating nuclear power or defense. Under the 10th Amendment, all powers not specifically federal are reserved for the states, and that includes public health. Now that's a bit of a categorical statement that's not entirely accurate. The federal government does have some role in public health, but as we'll see, the primary locus of public health authority is at the state level. And then there's this concept of cooperative federalism that we see in the environment, particularly over Superfund sites, where both the states and the federal government have co-equal jurisdiction. And there's always a debate of who cleans up the contaminated site, who pays for it, who should take control. And I want to reiterate, this historical tension for control over policy dates back to the founding of the country. It just manifests itself in different ways. Second concept that we need to elicit is the concept of preemption, which simply means that a higher governmental authority can preempt or block the actions of a lower level. For example, Congress explicitly can reserve power to the federal government, again, as it does in nuclear power. But likewise, the state government can preempt local municipalities. A good example of that is in tobacco control. In Michigan, at least in the early 2000s, the state largely preempted stronger local tobacco control regulations. I think that's now a moot issue, but it's a mechanism for the state through the legislative process to take control of an issue. Another example would be, it's not specifically preemption, but in Michigan and other states, the legislatures have blocked individual litigation against pharmaceutical manufacturers. So the state can preempt local, the federal can preempt the state. Finally, I want to talk a little bit about the concept of governance in our political system, because it applies directly to what we'll be talking about for the rest of this session, and that is the public health practice and structure in Michigan. So two particular concepts are important: the separation of powers, which I alluded to earlier, and checks and balances. Separation of powers, as I said, simply means that each branch of government has a separate set of powers and responsibilities and authorities for it to operate. So the judicial branch has its function, the executive branch runs the agencies of state or federal government, and the legislature makes the laws of the state and Congress. But without checks and balances, the concept that each of these can check the other. For example, a court can declare an act of Congress or potentially an act of a state legislature unconstitutional. The legislature and Congress or a state legislature can often override the president or the governor. Now, in the latter cases, the president or the governor can veto an act of the legislature, and the legislature can act to override that veto. Most of the time, Congress and state legislatures simply enact laws in collaboration with the governor. I know that's a concept that is increasingly remote from our lives, but in any event, in theory at least, the legislature and the governor will cooperate to enact laws. And finally, political accountability. I think one thing that got lost across many states during the pandemic is that public health has political accountability at every level. At the local level, for example, the health departments are responsible to either a board of health or the county commissioners, if for nothing else, through the budget. And we've seen an array of laws removing that authority and shifting public health authority to the elected officials, which, as we'll see, I think goes too far. Suffice it to say at this point that there is accountability at every level politically in the state of Michigan. Next, I want to talk a little bit about the administrative process, because this will help set the context for Colleen's discussion of the specifics about Michigan's public health code. First of all, what are the functions of a health department? Well, the first function, of course, is to keep people safe, to enact laws and policies that prevent the spread of disease, that protect the community's health. And health officers do that through a lot of mechanisms, as we'll see: education, moral suasion, issuing alerts, alerting the public about, let's say, the outbreak of Legionella in the water or contaminated food, but issuing regulations. And probably a key function of local health departments is to issue regulations, and the state health department to guide public health and keep the public safe. Along with regulations, health departments, state and local, issue policy guidance. And some of that's available online. The Attorney General has a bench book regarding its policies around public health. The state has an array of policies that it issues to help guide the public. And then health departments, in conjunction with local law enforcement, need to enforce the laws. Sometimes that means going to court to get an order to enforce the law. Sometimes it's simply issuing an order to cease and desist, let's say in an environmental situation, a PFAS chemical exposure. And it's no secret that many states and local health officers during COVID environment face considerable challenges in enforcing mask mandates and other restrictions. But for the most part, public health and law enforcement collaborate to make sure people are safe. One important function is having a public hearing. Before any regulation can be enacted, promulgated, the health officer will hold a hearing. And the hearings are important both for the public to express how it feels about a particular issue, but also for the health department. In my view, it's important to use the public hearings to generate community support for a potentially contentious issue, or to just provide education to the public on what the issue is, why it's important. But for the health department, it's important to identify the opposing arguments. what are the weaknesses of the proposed regulation? How can changes be made that bring a level of cooperation, that everyone buys into the regulation? And there are timelines for every regulation. You have to issue a notice to the public, give them a certain amount of time to comment, certain amount of time to hold the hearing, and then when the promulgated regulation will be effective. And as I mentioned, the judiciary has a role to play. When the regulations are challenged, the courts will determine whether the regulation is within the health department's authority, whether it's outside of that purview, whether it violates the state of Michigan Constitution or the federal Constitution, or even federal law. There are lots of remedies that health officers have to enforce its rulings and policies, regulations and policies. Most of the time we're talking about civil remedies, taxing, licensure, issuing an injunction, issuing a civil fine, issuing, as I mentioned, a stop and desist order. But there are some criminal fines. Some of the statutes involve often a misdemeanor charge for repeated violations of the law. I've long thought about market-based as a remedy because sometimes there's value in simply either deferring to the market or working closely with business and the community rather than using the civil or criminal mechanisms. Litigation is a last resort. For a time, I was involved in the issue of tobacco litigation as a mechanism for setting public health policy. My colleague Ken Warner and I were dubious at best that litigation is the best mechanism or even a second best mechanism for setting public health policy. There are some arguments where given, for example, the disclosure of documents in tobacco control, where litigation really made a huge difference. And we've seen some of that in the opioid litigation also, but it's really at best a second order strategy. But what we really focus on most of the time are the traditional public health strategies. Social distancing during the AIDS epidemic, that was a contentious but important public health strategy, and I've already mentioned quarantine and isolation. Yes, it's contentious in the COVID era, and we can talk about that in more detail later. Screening, contact tracing, and reporting, also very much a part of public health traditional remedies. How do we find out if someone has exposed others to a disease? Well, we use contact tracing, and we use testing, screening, and then we report, usually de-identified, but we've seen all of that in COVID-19, but in other areas as well. I think what I want to stress here is, and we'll come back to this, is that a lot of what we're seeing is in COVID is well within the traditional purview of routine public health response to an infectious disease or other public health threat to the public's health. There may be a difference in scale, but there's nothing new. And it's important to keep that in mind. Education is very important. It's really a critical aspect of public health strategies. How do we inform the public? How do we help them understand the nature of the disease, the nature of public health activity, why public health takes certain actions. Then there's moral suasion. To be blunt, maybe 20 years ago, moral suasion was an important part of public health, but I think that for a lot of reasons has lost resonance, lost balance in the current era. Another important point is that public health officers understand the trade-offs. And there was a lot of confusion about that during COVID, where public health officers clearly understood the economic and public health, mental health consequences of the lockdown orders, but have to make the trade-offs. If I don't lock down, are more people going to die? These were not decisions taken lightly. Every action involving social distancing, screening, all of the things I talked about before regarding public health regulations always include and understand the trade-offs involved. And I'm going to go quickly through the next set because I'm running out of time for my part of this section. Whoops, sorry about that, didn't work. 1 second, there. The weakest justification for public health intervention is to protect harm the self. It's an important one, but it's not the strongest one. The strongest one, in my view, is harm to others, with the second strongest being protecting vulnerable populations. Again, we talked about the market and litigation. But when we're largely using a justification for public health intervention to protect harm to others. I use this framework. You'll have the slides available, and I'll move on. I mentioned earlier that that public health is largely a state and local issue, and that's because of the police powers. The state has police powers to protect the public health, and as we'll see, those were upheld in the 1905 case of Jacobson versus Massachusetts, and are implemented through state public health codes, again, which Colleen will talk about. I mentioned the 10th Amendment, those reserve powers not delegated to the state, to the federal government, nor prohibited, are reserved to the states. That's how you get the authority at the state level. It's a broad delegation of authority to administrative agencies. And traditionally, we accord broad discretion to the agency, whether and when to notify the public of a Legionella outbreak. Again, have to follow the administrative procedures. Regulations must be within the scope of legislation. Quickly, Jacobson versus Massachusetts is the key case establishing the broad grant of authority for health departments to intervene. City of Cambridge mandated smallpox vaccinations, which even in the late 19th century were still contentious. The Reverend Henning Jacobson, no relation except for his contrarian nature, objected to and brought a challenge under the 14th Amendment. The legal issue is whether the statute, the mandate, was inconsistent with the essentially 14th Amendment. The Constitution secures to every person against the deprivation of liberty by the state. So we're talking about individual liberty interests, but as I mentioned, the trade-offs and the balancing, the court said, but the rights of the individual may be subjected to such restraint as the safety of the general public may demand. It's essentially a balancing test. Police power cannot be arbitrary or oppressive, but individuals are not free from restraint. There's no absolute right to liberty. In deferring to the legislature and hence to the regulatory agency, the court said what the people believe is for the common welfare should be upheld. The court basically said we're not experts. We have to rely on the state health department, on the legislatures to determine the best science. So you look for the public health necessity. Was it not necessary to act? Did the state use reasonable means? Are those means proportional? And what are the consequences if harm avoidance strategies, mitigation strategies are not taken? So the question is, does Jacobson remain a robust standard? Chief Justice Roberts, in the recent case on dealing with religious ceremonies during lockdown in California, clearly upheld Jacobson, but it's being challenged from a variety of directions. Certainly, it's the limitations on religious institutions has been a major source of litigation. So far, I think it's holding, but it's going to be challenged. There are significant challenges, and that robustness is under some threat. Then Colleen, Kathy, we could take questions now.
At the moment, we do not have questions that have come in during the session. We have questions that came in advance, but I think they'd be better held until a little bit later after we get through this next section. So I'm going to go ahead and introduce Colleen now. And again, if you do have questions, please enter them in the Q&A function. So our next presenter is Colleen Healy Boufides, JD. She is the Deputy Director with the Network for Public Health Laws, Mid-State Regions Office. She assists public health attorneys, practitioners, and advocates to use law to protect the public health by providing legal, technical assistance, training, and practical tools. Her current work focuses on public health legal authority and decision-making, collaboration between medical legal partnerships and public health, and legal issues related to environmental health. So thank you for joining us today, Colleen, and we'll turn it over to you.
Great. Thank you, Kathy and Arnold, and thank you, Peter. And thanks everyone for joining us today. Let me pull up my slides. Okay, great. So I'm going to spend a few minutes focusing specifically on the public health structure and legal authority established through Michigan's Public Health Code. Okay. So first, it's important to recognize that in combination with the state's inherent police powers as established under the US Constitution, the Michigan Constitution provides the basis for the state public health code and directs the legislature to establish laws to protect and promote the public's health. So public health codes vary widely across states and their specifics, but they serve many common purposes in general. And one of those primary purposes is to establish a structure for state and local public health service delivery, while another is to grant legal authority to state and local health departments. Some codes are very limited, providing minimal structure or legal authority for health departments. And some are much more comprehensive, like Michigan's, providing local health departments both with broader legal authority and with clearer standards for exercising their authority. This list of key articles in Michigan's Public Health Code helps to illustrate the code's breadth. The article we'll focus on most today is Article 2, relating to administration of public health services and establishing the state and local health departments. Other articles key to public health practice include Article 5, which relates to prevention and control of diseases. Article 9 addresses supportive personal services, which includes immunization requirements for children. Article 9 addresses immunizations, including requirements for, Article 9 includes immunization requirements for children. Article 12 covers some aspects of environmental health, including smoke-free laws, licensing of body art facilities, and public swimming pools. And then additional articles cover controlled substances, licensing of healthcare providers and facilities, and medical marijuana, among other topics. But as I said, we'll spend most of our time today on Article 2, parts 22 and 24 specifically. Part 22 focuses on the state health department, and part 24 focuses on local health departments. And I believe both of the sections for these were provided as handouts or will be. So local health departments are the first responders for local public health in Michigan, and they have primary responsibility for protecting the health of people within their jurisdiction. Every county in the state is required to either establish a county health department or join with other counties to establish a district health department. The city of Detroit is also permitted under the code and has in fact established a city health department. For single county health departments, the local governing entity for the department is the County Board of Commissioners. And the commissioners may appoint a county board of health as well, but it's not required. If a board of health is appointed, the Board of Commissioners still remains the local governing entity for a single county health department. For a district health department, on the other hand, a board of health is required and becomes the local governing entity for the health department. A district board of health includes representatives from each county's Board of Commissioners. The local governing entity for a health department is responsible for appointing a local health officer, and the local health officer then acts as the administrative officer for the Board of Health and the health department. The Public Health Code establishes duties and powers for local health departments that largely parallel the state health department, and we'll get into these specific duties in just a minute. While local health departments are primarily responsible for public health within their jurisdiction, the state health department's role is a bit different, even though it has parallel legal authority. One of the state health department's key roles is to provide leadership and specialized services. For example, the state health department creates data systems and hires experts and provides lab capabilities that would not be efficiently reproduced at every local health department. In addition, the state health department has general supervision over the health of the people of the state, and the department is explicitly authorized to intervene if a local health department is unable or unwilling to perform its responsibilities. In addition, the director of the state health department can respond to address a menace to the public's health anywhere in the state. So this slide shows the general grant of authority to state and local health departments. They are directed to investigate, prevent, and control diseases and environmental health hazards, prolong life, and promote the public's health. They are also directed to provide expertise and education on public health. They have powers necessary and appropriate to perform these duties, if not otherwise prohibited by law. In addition to these general powers, the Public Health Code provides several specific actions that a health officer can take. For example, a health officer may order the abatement of a nuisance or the correction of an imminent danger to the public. The health officer can issue an emergency order to control an epidemic or a warning notice to a person with a hazardous communicable disease. And violations of a health officer's order may result in civil penalties. The health officer can also seek an injunction to correct a condition which adversely affects the public's health. So each of these actions depends on a health officer's exercise of their professional judgment and their public health expertise to determine that there is a credible threat to the public's health. To issue an imminent danger order, for example, the health department must first determine that a threat exists. To issue an emergency order, the health officer must first determine that control of an epidemic is necessary to protect the public's health. These professional judgments involve consultation with the medical director as appropriate. So let's take a closer look at one of these provisions, the imminent danger provision. A comparable provision exists in both parts 22 and 24. So both the state and local health departments have this authority. The provision defines an imminent danger as a condition or practice which could reasonably be expected to cause death, disease, or serious physical harm. And it provides that a health officer's order may specify an action to be taken to correct the condition or prohibit the presence of individuals in locations where the danger exists. And I'll share a couple of examples of imminent danger orders in just a minute. This provision is one that we've seen used more often during the COVID-19 pandemic. This authorizes the state and local health departments to issue an order to protect the public's health during an epidemic. And this authority exists only if the health officer determines that control of an epidemic is necessary to protect the public's health, as I mentioned. The order may prohibit gatherings or establish procedures to ensure continuation of essential public health services. So, for example, an epidemic order may be in part aimed at preventing hospitals from becoming so overwhelmed that they cannot provide essential health care. And so trying to reduce the spread of disease to ensure those continued services. Another key provision in the communicable disease context is actually, it comes from the state health department's communicable disease regulations. In addition to operationalizing disease reporting requirements, these regulations allow health departments to investigate disease cases and institute appropriate isolation or other barrier precautions. They also authorize both local health officers and school officials to exclude kids from school if they have a communicable disease. And they allow local health officers to exclude a child from school if the child is not vaccinated or is otherwise considered susceptible to the disease until the health officer determines that there's no likely risk of further spread. And finally, as Peter mentioned, there are a range of non-legal interventions that health departments can and frequently do rely on. Educating the public is an important one, along with providing recommendations for voluntary measures and issuing advisories and warnings. A medical director's role is very important. At both the state and local level, administrative health officers must have public health experience, but do not need to be physicians. However, if they are not physicians, there must be a medical director appointed who is licensed to practice medicine. The medical director's role is to contribute their medical judgment and expertise to the local health officer's decision-making and provide the medical content for policies and programs. As I mentioned, I wanted to share two examples of imminent danger orders. This first one is very routine. In this case, an imminent danger order was used to address a seasonal flu vaccine shortage. Since there were not enough flu vaccines to provide one to everyone who might want one, the state ordered healthcare providers to limit these vaccines to persons in high-risk categories. This next example is one that did raise some objections. In this case, an imminent danger order was used to respond to a situation where vapor intrusion caused hazardous indoor air quality in certain homes and businesses. The local health department ordered that the affected properties remain unoccupied until remediation occurred and the air quality returned to safe levels. The objections here arose because there were landlords and businesses who could not collect rent or run their businesses for a period of time through no fault of their own. But the other side of that coin is that there were tenants and employees whose health would have been endangered if they were exposed to these vapors. Finally, I wanted to note that the Public Health Code grants local health departments, as Peter mentioned, authority to adopt regulations that are necessary and proper to protect the public's health. They must provide notice in a public hearing before adopting the regulations, and the regulations must be approved by the local governing entity. So this covers, some of the key provisions of parts 22 and 24 from the Public Health Code, and we'd be happy to take any questions now too on these particular aspects.
Colleen, I think this is the right time to throw out a question that came in advance of the session. And that's, why does Michigan have a decentralized public, oops, lost it. Hang on one second. why does Michigan have a decentralized public health system? Is it better? Is it better for the people of the state that everything is not handled through the state health department? I think, please correct me if I'm wrong, but I think Rhode Island may be the only state in the country that does not have local health departments.
Well, it depends on how you define it. In Florida, for example, there are local health departments, but they are arms of the state, effectively. So they don't act independently. I don't know, Colleen, do you know why? The code was revised in 1978. Our former colleague, recently deceased Toby Citron, was a major drafter of that law. And my guess, Denise Chrysler is on the call, she might know. My guess is it was more or less a political compromise. And so what I think, so there are two aspects of this question. Let me answer the specific question, the other specific question. Is it better? There's been research, including a study that I conducted for the University of Michigan's Center for Healthcare Research and Transformation chart on the variations, performance variations between centralized, decentralized health departments. And I couldn't come up with a clear answer to that. And I don't think there really is a clear answer. It's really a policy choice that a state legislature makes. There are pros and cons, as you might expect, to each mechanism. I actually clearly prefer the delegation to the local health departments, because public health really, with the exception of something like the COVID-19 pandemic, really is a local matter. A PFAS outbreak, for example, in Washtenaw County is largely contained within Ann Arbor. So while the state certainly has an interest, the activity is going to be at the local level. Same for the Legionella outbreak during the Flint water crisis. But a centralized department has the advantage of one place where everyone can look for the regulations. You don't have variations across health departments. You don't have different revenue allocations as we do in Michigan. But I don't think there's any systematic evidence that one structure is better than another. But I do want to take the opportunity to reinforce something that Colleen talked about, and that is that Michigan's code sets up a parallel structure between the state and the local. And there's no clear mechanism in the statute, in the legislation for resolving potential differences between the state and the local government, local health department. So I think essentially the idea is work it out politically, come to some political resolution of it. Sometimes the state is going to be in a better position, sometimes the local. Again, we saw that in the Flint water crisis, and Colleen led an effort to examine the ways in which the legal issues contributed to the Flint water crisis and its resolution. And there was contention between the county health department and the state. There was contention between the local government and the Michigan Department of Environmental Quality. Essentially, they're political issues. Colleen, anything you want to add to that or subtract?
I think just drawing from our work looking at the Flint water crisis, one of the things we observed was there was overlapping authority between multiple agencies, but that overlap can lead to gaps. So it creates an opportunity where you have multiple agencies that can intervene. You have a state health department that could take certain actions, a local health department that could take certain actions, and others. That could mean you have, lots of coverage, or that could mean you have lots of gaps because there's a lack of communication or a lack of ownership. So I think that just kind of goes to Peter's point that there are pros and cons to both. And perhaps a lot of it is in implementation.
Yeah, and the other part of the question, another part was, do citizens fare better with the centralized public health system? Again, I don't know that there's a clear empirical answer to that question. I would argue that one advantage of a decentralized system is that citizens have more access to the decision making. That the local citizens can lobby the health department, can talk to the health department. Having said that, though, it comes with a caveat, and that caveat is what we've seen in terms of the threats to public health officials, the actual violence to public health officials in COVID-19. It wasn't limited to local. In Ohio, for example, by all accounts, Governor DeWine did an excellent job responding to the outbreak, the pandemic, and had an excellent state health officer who was basically driven out of office, as others have been, because of citizen resistance and threats to her family, threats to herself. So this was not only, the threats were not only directed to local health officers, but to state health officers as well. That said, I do like the ability of local, of county commissioners, let me rephrase that, of individual citizens to have access to the health department either directly or through their county commissioners. I was also, for several years, the chair of the Washington County Health Department's local board of health. And one of the things that I saw was the ability of citizens to come before the county commissioners and address public health issues. For example, the issue of vaping in public generated a lot of comment from the public, both for and against, and it gave the commissioners a sense of what the trade-offs would be.
Which is an excellent point. And I think we have to always be reminded of how large and diverse our state is as well. And so the other advantage to local, is the ability to address the uniquenesses of communities, jurisdictions, regions of our state. And, the logical, comparison is, the difference from the UP to the city of Detroit, and how, one set of rules is not going to work in those diverse communities and unique settings. And so that is another reason I've often heard of why it's important. And you were right, Peter, I've been able to confirm with, professionals, experts, Florida is the state that, while the local health departments are an arm of the state health department. So that is, you are correct that is the difference. Otherwise, states do, other states do have local, where they have their own jurisdiction and they collaborate with the state health department and share authorities, but not directed by.
South Carolina.
The other question I think we're going to hold to is as well. Okay. All right. So Colleen, are you done? Should we turn it back to Peter at this point?
Yes, back to Peter.
Okay.
Okay.
So let me get caught up. a review for the audience. Okay, so I want to talk about public health law in practice. And here I want to thank our colleague, Denise Chrysler, for her work on executive decision-making in public health. Denise is the co-director, along with me, of the Mid-States region for the Network for Public Health Law. And as I suspect many of you know, a longtime public health attorney for the state of Michigan. And we use law to protect the public health. That's been the theme of this presentation. But we have to then ask the question, how do we operationalize that? How do we implement that notion? And Denise developed this slide and approach. And it's first, I asked, can I take action? Must I take action? And should I take action? So the legal question, the first question is, do I have the authority? And given what Colleen talked about with regard to that, the broad grant of authority under the Michigan Health Code, the answer is often yes. I have the authority. So can I, in many cases, in almost all cases where the public health is threatened, the answer will be yes. Then I want to ask, or a health officer should ask, must I? Does the law leave me no choice? Sometimes that's correct, but rarely. I would argue if there's an infectious disease, it's pretty mandatory to take some action. But for the most part, it's a question of policy question. How should I exercise my discretion? And the key point here is what Colleen mentioned. It's exercising the health officer's professional judgment. That includes his or her understanding of the science, understanding of the nature of the exposure of the public health, of the threat to the public's health, the consequences for taking action or not taking action. Remember, not taking action is a policy choice. It has implications. Do I have the authority? Do I have the power? What's the scope of my power? What are the interventions? And an important question is who else has power? And that gets to what Colleen was talking about just during the questions. What we saw in the Flint water crisis was this set of overlapping jurisdictions that create legal jurisdictions that created two types of problems. One, no one agency had overarching control. Second, lots of gaps that just weren't filled, and it allowed the crisis to spin out of control. Well, it was one of the factors that allowed the crisis, that exacerbated the crisis, essentially. So it's, do I have the power? What's the scope of it? And in Michigan, I think the scope is quite broad. That's the point of 2253 for local health departments, that broad grant of authority to protect the public's health. And we talked about the range of the interventions. But the core is really, how should a health officer exercise that discretion? Sticking with the Flint water crisis example, we know there was an issue about whether or not the public should be notified of the Legionella outbreak. Full disclosure, I was a consultant to the administrators, attorneys on the charges. I presume still faces, but the issue is, what's the need for the public to know? What's the best way of informing the public? And when should the public be notified? these are all judgments a health officer needs to make based on the science and the factors that we've already talked about. So how should I act? When? What should I consider? And I want to reiterate that I think that the full range of considerations that health officers across the country took into account before issuing lockdown orders got lost. Maybe it was some poor messaging. Maybe the health officers and governors could have done a better job articulating the trade-offs and what was taken into account, but they all did. And what are the policy, considerations? There are also ethical considerations. We want to take into account the respect for an individual's right to make his or her own choices, non-maleficence, non-maleficence, I think it is pronounced. First, do no harm, beneficence, and do good, and treat all people equally in justice. The law defines what an agency can do. Ethics define what an agency should do. There's an interesting set of public health ethics and frameworks, but that's the subject for another day. All right, so that takes us back to COVID-19. And back to our Colleen's and my initial framing of this whole session, and that is the need to balance individual personal freedoms, 14th Amendment freedoms, we often call them, versus the need to protect the public's health. How do we think about that? Well, one way of thinking about it was through social distancing. One may object legitimately, it's a contentious issue, that the social distancing measures went too far. One might say the lockdowns were not effective. What that position needs to remember is when the pandemic hit, nobody knew how lethal the virus was going to be. We did know it was highly infectious and that hospitals were being quickly overrun. If you think that the lockdown orders were inappropriate, do you think that simply allowing the virus to infect as many people and create herd immunity is a better strategy? Or is there an intermediary strategy that should have been taken? We had a lot of contention over mask issues, some very inconsistent messaging from CDC, which complicated matters, and it's still contentious. Do masks work? What's the science? What are the implications for children, for schooling? We know there have been some significantly adverse consequences for children, not necessarily over mask wearing per se, but over keeping schools closed. Could we have done better? What can we learn for the next time? Likewise, we know a remarkable success in generating the vaccines. Given the safety profile, given that billions of shots, arms have been, given that there have been over 1 billion shots worldwide with relatively few adverse consequences, should they be mandated? Should everybody be expected to get a vaccine that's safe and reliable and protects the public health? If they're discretionary, how do we encourage people to get vaccinated? Because we know that's how the pandemic ends. Should we have had vaccine passports? All right, if you as an individual, if we believe the objection to mandates that it's a personal choice, then is it fair for the community to say, all right, if you make the personal choice not to be vaccinated, then you can't go into a venue like a restaurant. You can't go into my store. You can't remain employed in my factory, or you can't remain employed in my health department. How do we provide due process? We think of due process as being an individual fact. If, for example, I'm quarantined because I've been exposed or isolated because I've contracted the disease, can I go into court and challenge as an individual? Yes, I have that right under the Michigan Code and under the 14th Amendment. But how do we handle this large population that's now being denied, being quarantined during the breakdown, the early lockdown orders? Is there a mechanism for challenging those orders on due process grounds? That still remains, there's a lot of dispute in the legal literature about the feasibility of that. Some of the key legal issues I alluded to before, First Amendment freedom, free exercise of religion has been a major challenge. Freedom of assembly, free speech. For the most part, while there have been some incursions on the the COVID-19 executive and health department orders under free speech grounds, most of the challenges have been about the free exercise of religion for a lot of reasons. They're more organized. They're more contentious. There's less wearing. It's hard to see how wearing a mask is an intrusion into free speech. And you may have to shout louder, but it doesn't impede your ability to speak. There are data issues. The Network for Public Health law received an inordinate amount of questions from local health departments about data privacy, security, and transparency under COVID-19. School issues emerged late once schools were reopened. A number of technical assistance requests about schools. And as I mentioned before, there's an issue of the feasibility of enforcement. There was a real reluctance in some parts of Michigan and certainly other states to enforce the laws. And it's an issue that needs some attention for the future. A recent decision in county court in Michigan struck down section 2253 as a violation of what's called the non-delegation doctrine. This simply means that the legislature cannot delegate its functions and responsibility to another branch of government, in this case, to the administrative branch, the health department. The court said that because these issues are legislative in nature, whether to issue a lockdown, whether to mandate masks and or vaccines, that they should be decided by the legislature and not delegated to the health department. There are several problems with this. One is that public health can't function if the non-delegation is enforced, because there's no way the legislature can adapt to a rapidly evolving health threat. Second problem is that it goes too far, in my view. There's reason to believe that there's no history of abuse by Michigan's health departments, for example, that would suggest the health officers act beyond their purview. But that's something that will make its way through the Michigan courts. I don't expect that decision to be upheld. Okay, but want to finish up quickly with a sense that what we've been talking about is a broad grant of authority here for public health, but there are limits. The police powers do not equal a police state. And there is no tyranny involved in lockdowns at the beginning, nor mandating vaccines, but that is my personal view. What is not a personal view is that there are limitations, the separation of powers. The state legislature can act to override the decisions of the governor or of a local health department. The assignment, the agency actions must be within the scope of the regulations, for example. So that it's not, while it's a broad grant of authority, it is not unlimited. As the court in Jacobson versus Massachusetts said, the action taken cannot be arbitrary or oppressive. It's up to the health officer to justify its actions and why its actions are necessary to protect the public health. That's the essence of what Colleen set forth. But there are these constitutional limitations. The 14th Amendment liberty interests are not trivial. They need to be taken seriously. Due process is functional. Those who think the regulations and the orders go too far have every right to challenge them in court and the freedom of religion that we talked about. And if there's a taking, if the regulation goes too far in taking property without due process, without just compensation, the state must pay for that. Now that rarely happens in a regulatory matter, but if the state were to arbitrarily take property, confiscate property without full justification, then it would have to pay for that intrusion. My view is that public health law is and should remain a local matter, as Kathy and I were discussing before. It's the level that can act quickly to mitigate a public health emergency. It's the locus of public health expertise, along with the state. I want to emphasize here that MDHHS has that same level, that same capacities to act quickly, an exceptional level of public health expertise to craft responses to address specific threats. But the legislature just can't be involved in all public health threats. Determining the nature, the scope, the duration, and severity of them is an administrative function. It's not a legislative function, which is why I think the court is wrong on the non-delegation authority and why it would completely undermine public health in ways that I think would be adverse, deleterious for the state. Finally, law is the foundation for public health. it's really important to understand not just the terms of the code, but why we have the code, why the Michigan legislature adopted it as it did, why it provides a broad scope of authority, but also why that scope of authority requires judgment, professional discretion, and knowledge to be used effectively. And yes, there is a blurring of law, politics, and ethics, and I'm comfortable with that. And I think the health officers throughout Michigan are equally comfortable with it. And the reality is that Michigan has an extraordinary public health community. I've interviewed in many states, but I've done a lot of interviewing and collaborating with the Michigan public health personnel, and they're exceptional. And we shouldn't forget that. They're dedicated and committed to keeping the people of Michigan safe in this brutally contentious era. They have my admiration and support. And thanks very much, and take your questions.
So I'm not seeing any questions. There is another question that came in advance that I'm not sure there's enough information here for either of you to answer, but you may be able to refer this question somewhere else. But when a facility is not licensed with LARA and are putting those in their facility at risk with their practices, what arm of the public health system would have the jurisdiction to leverage the facility to make changes? If there is really not enough information there to answer it, that's fine. We can follow up.
No, LARA is an independent agency. So I'm just not sure that it's a public health question. I guess that's what I'm not understanding. How it's a question about medical practice, a licensure issue. I mean, we saw some questions from medical officers in COVID-19 about their authority. So I can imagine if the questioner thinks that the medical officer went too far, then there could be a complaint to LARA over licensing. If the question is about the health officer's role in the medical officer's role in responding to COVID-19 or another issue, then I think, Colleen, you covered this. You want to?
So I was thinking there might be a few other, I'm not quite sure what type of facility is referring to, but if it's, for example, a food service establishment, there would be a role for MDARD and the local health department, and there would be potentially a role for the Liquor Control Commission. And so I think looking at, what type of facility it is, and so what laws it's subject to and what different agencies are responsible for implementing those laws would be relevant to determining who all has authority, and kind of goes to that question that Peter was talking about in response to can I and who else has authority. And so looking at who might have different roles, and it might point to the importance of health departments having broad authority, so that if there's not a specific assignment of authority with respect to this facility, whatever the facility is, then the health department has this general authority to address threats to the public's health. And so maybe that is where the state or local health department would come in. It is just a little bit difficult to answer more specifically without knowing what type of facility and
we can follow up. And we
Yeah.
can follow up with the individual person afterwards and see if we can get a little bit more information. Thank you both
Sure.
for that. Another question. Do you think revision or updating of the state health of the public health code is necessary given recent circumstances, and what has changed since the last revision, or legally fraught and risky?
No, and the reason is that the public health code has worked, in my view, very well since its revision in 1978. And I would caution, my caution would be not to take a once in a century event, COVID-19, to take action that would potentially undermine public health, routine public health. And we need to, and that gets back to a point I made earlier on. My view is that there's a difference in scale, obviously, when you lock down a state, but how often has that happened? Since 1945, when the response to rioting in Detroit during the war, when the Emergency Powers of the Governor Act, or whichever one was enacted in 1945, it's been used once, I believe, and that's in 2020 for the lockdown on the pandemic. We're dealing with a once in a century event. Don't make policy based on that. Think about the routine use of everything that Colleen and I have talked about as being the essence of public health law and public health practice. And do you really want to, out of concern for what health officers had to do for COVID-19, to take action that might undermine that? If there are tweaks that should be made, yes, that's fine. But I implore you to keep the structure as it is. It works well. It's worked to protect the citizens of Michigan from public health threats. It's a good question. It's an important question. And I would encourage you to look at what's happening in other states. In Kansas, for example, the legislature responded to COVID-19 by shifting authority from the health department to the county commissioners. Why the county commissioners want that level of authority is not clear to me, because what's going to happen when they have that political authority and responsibility, you've got a couple of potential consequences. One is really highly qualified staff leave because they're no longer autonomous. They no longer have any independence. Yes, they always have political accountability, but they no longer have the real authority to take action. How is the politician going to handle an environmental outbreak where he or she or they being the collective county commissioners, have no knowledge of environmental exposures? We live in an era of contentiousness, lack of trust in government. The solution isn't to remove authority.
We are approaching the end of our time. We do have another question. I think we can answer that offline in the interest of time, unless you want me to take it, Arnold, up to you. I can't hear you. You're on mute.
Let's take it and make it the last one, shall we?
Okay. How do we support a local health department when its county board of health makes decisions that blatantly disregard the public's health, such as chronic defunding of health department or firing health officers who disagree with the political agendas?
That's a great question. I don't think we have the answer. I don't have the answer. You can rally the public. It's going to be up to the public to decide whether the actions of the Board of Health are consonant with their responsibility. What the health officer can challenge the decisions in court, arguing that the Board of Health has exceeded its authority, would be really, to me, the best way of going about it, but also generating public support would help. Colleen,
I think that public support is key. If you have the Board of, the Board of Health, I'm assuming that's in a district health department then is comprised of county commissioners and they are elected officials and trying to be responsive to what they think their constituents want, presumably. So making sure that I think sometimes the loudest groups are not necessarily representing the majority. And so making sure that other opinions are heard and particularly that the one that might be less vocalized is heard. If it's in support of a health department and that's not the one that's being loudest, then maybe that needs more airtime kind of. So.
It was an excellent question and something I know many of us have wondered how best to address it when we're seeing it. Arnold, I'll just do a quick reminder and then I'll turn it back to you to close out, but reminder that this is a two-part session. The second part that will include local health officers is scheduled for February 28th from 9:30 to 11, the same time this was. We will have new presenters that will piggyback on the baseline that this session established. Thank you again, Peter and Colleen, for your hard work on putting this together and your expertise with us today. And Arnold, I'll give it back to you to close it up.
Well, thank you very much, Kathleen, for putting together this, what was a very informative and at the same time thought-provoking session. I really appreciated the information shared by Drs. Jacobson and Boufides today. Plenty to discuss moving forward and certainly plenty to think about. Thank you both. And thank you, Kathleen, and thank you again to IPSR staff, Cindy Kyle, for helping us with logistics with this meeting. And again, to the Michigan Health Endowment Fund for their continued support of these sessions. As Kathleen noted, this is the first of a two-part series, so please join us for our second on February the 28th. Thanks to everyone and have a great week.
bye, thank you.
Thank you.
Thank you.